All right, we'll give it about 10 more seconds before we get started to let people join. Okay, we've got a good number of people. Welcome, everyone, and thank you for joining us for today's CLE hosted by the Dallas Association of Young Lawyers. Today, we'll be diving into a topic that every attorney touches, whether you're drafting deals or litigating them. These so-called boilerplate provisions often get less attention, but it can have a massive impact on risk, outcome, and disputes. Today, we have two panelists with us. First, we have Doug Clayton. Doug is a respected partner at Cansey Hanger LLP and serves as chairman of the firm's business transactions practice group. He brings over 2 decades of experience advising clients on complex mergers and acquisitions, corporate finance, securities offerings, SEC compliance, and a wide array of business transactions. In addition to his legal practice, Doug is actively involved in the entrepreneurial community, having served as the chair of the board of Tech FW, a nonprofit tech startup accelerator and incubator dedicated to strengthening the North Texas innovation ecosystem. Next, we also have Melissa Gray. Melissa is the founder of The Law Spot, a boutique firm known for its client-focused approach to serving small to mid-sized businesses, especially women-led enterprises, with expertise in trademarks, contracts, and entity formation. Melissa's commitment to excellence has earned her recognition in D Magazine's Best Lawyers in Dallas 2025, underscoring her leadership in intellectual property and business law. Thank you so much to our panelists for educating us today on these important provisions. And with that, let's get started. There are some housekeeping items. We will put the CLE code in the chat during the presentation, so be on the lookout for that. And also, if you have any questions, please use the Q&A function in your Zoom, and we will try our best to answer during the presentation or at the end during the Q&A section. So first, here's our agenda. We're going to go into why boilerplate clauses matter, indemnification, limitation of liability, reps and warranties, and other key clauses. Then we'll have some practical tips and takeaways and some Q&A at the end. So Melissa, if you'd like to get us started on why these matter.
Absolutely. Thank you for having me, and happy to be here today. I know this is geared at our younger lawyers, so happy to talk about this topic. And as I progressed in my career, also understood the importance of these more and more. These boilerplate provisions often show up in the miscellaneous section of the contract, which is sort of probably after you've already read pages and pages, and you get to the end and you're like, oh, that's fine. But these really are kind of the rules of the game as far as enforcing the rights that you've just spent so much time advocating for your client, right? So they're not something to overlook and pass over. They definitely are critical in an enforcement context, because the choice of law, choice of venue, choice of forum is where these disputes will be held, and they can make it impractical sometimes to enforce the contract altogether. So the bottom line is they do matter, and if you draft them poorly, they could cost your clients quite a bit of money.
All right, and yeah, and I'm also very like to express my appreciation being here today. One of the first things we wanted to talk to you guys about was indemnification section. So I think of this category, especially in the context of a merger or acquisition transaction, where there's going to be several pages on indemnification often, and so that you can use the term colloquially to mean just any time one party is responsible for picking up the damages of another party. But in the M&A context, it can mean both a damage that you have directly to the other party in terms of a breach of a rep or warranty or a breach of a covenant, or it could mean a third party indemnification where you have one party or the other is harmed, or harms some other third party, and now you're getting into the situation of who's going to be responsible for defending those claims and paying those claims.
Yeah, so just some practical drafting tips with respect to these clauses. The term loss is what you want to focus on, and defining that loss clearly. If you're going to carve out anything like gross negligence or breach of intellectual property claims, then make sure that those are not included in the indemnification. There's this concept of indemnify and defend. So make sure you understand whether the indemnification is just that, or if there's an obligation by that party to step in and provide a defense. So those are all things to consider as you're sort of drafting. And Doug, I'm going to let you speak to the sole remedy piece here in the M&A context.
Yes, that's one thing that you don't what you don't want to happen is to spend hours negotiating a very detailed indemnification provision that sets forth maybe baskets and caps and limitations on indemnity, but you exclude the sole remedy clause. If you don't include a provision that says the indemnification under this agreement is the sole remedy that you have for a breach of a rep or warranty or covenant under the agreement, then all your caps and baskets and limitations can be for naught. So that's certainly something you want to see as part of the indemnification section.
I think this one's for you, Melissa.
Okay, sorry. We wanted to kind of give you all an example of a poorly drafted clause and a better option. Now, the caveat being which side of the coin you're on in your representation, right? One might benefit you more, but all of this to say that take these as ways to strengthen and provide clarity in these clauses. So one example is the contractor agrees to indemnify the client for any and all damages or losses. That's a lot. That's really broad. They didn't define losses. So, improving that would be giving clarity on the scope, adding limitations, and then making sure there's these defenses and notification procedures in the event that someone triggers the indemnification clause. So a better outcome would or a better draft would say the contractor shall indemnify, defend, and hold harmless the client from third-party claims arising out of gross negligence and willful misconduct, provided that the client notifies the contractor and allows the contractor to control the defense. So there's these this clarity of who's responsible for what and when that really makes that a better draft.
Great, thanks, Melissa. I have one question for you. When there's a power imbalance, how do you advise clients on negotiating indemnity provisions?
That's tough. And a lot of my clients are on the smaller side. So they're like, the David to the Goliath, and they really want to accept the terms. What I try and do is prioritize narrowing the scope, right? Okay, what are you really worried about? What are breaches that are actually within our control? Can we cap the dollar amount? Can we carve out like speculative or unforeseen risks for them? But even a party, that's small can get an agreement on like who, what, and when are we responsible? And if they just need to be aware, and then maybe there's other opportunities to mitigate that risk through insurance or processes and procedures that you can strategize with your client on. But certainly the narrower, the better, if they can have any whatsoever.
Great. Thank you
Yeah,
for
I would
that.
totally agree with that. The indemnification section is often just the most complex section in an agreement. So you really have to think through exactly what might be happening in the future and how that might and how the indemnification section is going to possibly implicate your client based on events that, as they say, like predictions are hard to make, especially about the future. So that's something you have to think about as you draft those clauses.
Mhm.
And so along those lines, we talk about limitations of liability. So if you are going to be responsible for something, certainly you want your client to be as limited as possible. So some things to think about, some of which Melissa touched on earlier, are caps. Can you say, okay, in no event is your liability under this agreement going to exceed, say, $1 million or $100,000, or the amount of fees that you earned in the last 12 months, or there's all sorts of different ways you can calculate the cap, but having some sort of cap to put you at ease that in worst case scenario, you're not going to be liable over a certain amount is certainly nice to have. You might also look at, what can you carve out of the losses? Maybe confidentiality or intellectual property or willful misconduct. All sorts of ways that you can put limits around these risks so that you don't have unlimited risk. And well, what types of damages are going to be included? Are you going to include consequential damages or exemplary damages or punitive damages, or damages measured in a loss of profits? All those sorts of things are things you could potentially carve out if you're on the side that's doing the indemnifying, and so that would be something that you certainly should think about asking for. You don't always get it.
Great, Doug. So with these carve-outs and the liability caps, how do you reconcile indemnification carve-outs with the liability caps? Is there a best practice?
Well, I think that it's certainly the case that those two provisions are going to interact with one another, because the broader that you make the total liability, the more some caps make sense. Whereas if you have a whole bunch of limitations on one side, the other side's going to want more. It's kind of like squeezing a balloon. The more you push on one side, the more you're going to get pulled on the other side. So I don't know that every deal is different, and it certainly depends on facts and circumstances. But I would say generally the broader the indemnification limits, then the more you're going to have ability to cap, and vice versa.
Awesome. Melissa, do you want to give some drafting tips?
Yeah, absolutely. So the more precise you can be, the better. And as Doug just alluded to, aligning the liability limitations with the indemnity provisions is going to be a balancing act, right? You got to understand how one, even if you make a change to one, it might trigger a response from the other party that will require a change. The ambiguity is what gets people in trouble with respect to enforcing these limitations on liability. So if you are the one drafting it, courts often side against you because you're the one drafting it. So if it was ambiguous, like that's on you. So precise language is the way to protect your clients for this type of provision.
Great. Doug, do you want to look at some poor and good clauses for us?
Absolutely. So so here's an example of a poor clause on the left-hand side of your screen. In no event shall either party be liable for any damages. Well, you can kind of see right away where that does probably not going to work. That you almost don't have an agreement if neither party can be liable for any damages under any time, and you question whether it would even be enforceable under those circumstances. So what we want to do is kind of tighten that up and kind of try to explain more narrowly where we're trimming back the liability. So a better example is on the right-hand side of the screen. Except for liability arising from gross negligence, willful misconduct, or a breach of confidentiality, each party's liability shall not exceed the total fees paid under this agreement. And you can see why that's better, because you're adding specific areas of carve-outs, and it makes the clauses enforceable by capping the liability by a reasonable amount. We're not saying no damages. We're just saying, hey, only fees paid under the agreement.
Melissa?
Fun reps and warranties. Yes. Oh, you want to go to this next slide? Core concepts here for reps and warranties. These are the statements of fact and promises of truth. They're very common in M&A deals. The parties are saying, we represent this as the truth and warrant that this is true. So those are critical. So you want to make sure it's actually true, first of all, because then you're opening yourself up to liability. So in addition to the M&A context, licensing deals, supply contracts, these are also common. So making sure that it's clear who made the representation and when they survive the agreement itself are just sort of core concepts that you want to make sure you understand for these. And I think there's some good tips on the next slide for making those.
So some of these tips include if you're the one making the reps and warranties, you want to add as many knowledge or materiality qualifiers as you possibly can. To our knowledge, this is true. This is true in all material respects. So the more you can narrow the reps and warranties, you're less likely that you're going to be liable for them. And you need to define a specific survival period. So typically, in an M&A transaction, your reps and warranties are going to survive, at least in a private company deal that doesn't involve insurance. You're going to have a survival period, but can you limit that to 6 months, 12 months, 18 months? Obviously, the shorter the period of survival, the better for the party making the reps and warranties. And you want to align with the due diligence and disclosures. So, kind of as Melissa alluded to earlier, if you have a rep and warranty that's just not true, based on the due diligence and the disclosures made, you're going to have a problem. So, you want to make sure if there is a rep or warranty that's not true, you're either going to need to change the rep or warranty before you sign the deal, or reference a disclosure schedule that carves out what's not true about that rep or warranty. And you also want to typically there's kind of there's a carve. The concept of fraud is often used as a carve out to limitations on reps and warranties. So for instance, you'd say, the most you could possibly get sued is $1 million under this agreement unless there's fraud. So if you have a carve out for fraud, you want to make that as specific as possible so that there's no question what you mean by fraud. Do you mean constructive fraud? Do you mean securities fraud? So the sellers would want to have a definition that refers and make sure that there's an intentionality concept, that you don't want to have like a reckless standard of fraud where you're kind of accidentally commit fraud. It has to be intentional breach of an explicit rep or warranty that the buyer reasonably relies on. And if you have that kind of really narrow definition of fraud, then you're okay carving it out from other limitations. There's also the concept of sandbagging, where let's say the buyer knows one of the seller's reps and warranties aren't true. Can they still sue for a breach of a rep or warranty? If they you can have a pro sandbagging clause or an anti sandbagging clause, and as the seller, you usually want an anti sandbagging clause to say, hey buyer, if you know something's not true in my reps and warranties, you can't wait until after closing to sue me over it. You got to tell me now. Whereas the buyers want to have a pro sandbagging clause to say, hey, even if we know something's not true, if you breached a rep or warranty, you're going to get sued because we're relying on your reps and warranties. So that's often a provision that people fight about in a M&A context.
Yeah, Doug, and you were telling me usually the consensus is you just leave it off, right? And then everyone can fight about it later.
That seems like more often than not, that's the way we end up, because neither side wants to budge on that issue.
Yep. Which is an option, right? As you're working through these agreements, you don't always have to agree on the language. Sometimes the agreement is we're just not going to have it, and we'll fight about it later. So that is a solution to consider as you're kind of working with your counterparts on some of these options. But for reps and warranties, a poorly drafted example, the seller represents all the product will be free from all defects and comply with all laws. Okay, all laws, that's pretty that's a pretty heavy lift. Which laws are we talking about for which kind of thing? You want to avoid absolute language like that and qualify with these knowledge, materiality, like thresholds. So a better example would be to say the seller represents to its knowledge and in all material respects that the product is free from all material defects and is in compliance with applicable laws at the time of sale. So if I read that, I'd be like, okay, we need to define materiality, right? So there's all these options to sort of make sure everyone's on the same page in terms of what you're representing and warranting in that instance. So
Melissa, how do you balance thoroughness with risk in drafting representations and warranties, especially in a fast-paced deal?
I think for all of these, it's important to know your client and to know what their biggest business risks are from, both just a day-to-day practice, but also like regulatory requirements. So, these catch-all reps might be impossible to verify, but if you know, okay, we're in a situation where we're importing products, we're manufacturing products, and we're saying that it's applicable with all laws. Well, if we're importing from a country that is using child labor, for example, like we want to be able to say that we did our diligence, that the supplier doesn't use child labor in their process. So you just have to know where the key risks are in relation to the industry and the business practices of your client. And you can't draft out every single risk. There's always going to be some risk. That's the nature of doing business. But if you can really hit the key points and then again mitigate the risk in other ways through other avenues of business operations, insurance, and other areas, then that's the best way that I've found to do the balancing act.
That's a great tip. Thanks, Melissa. So now we're going to go into some other boilerplate clauses. Doug, you want to start it off with force majeure?
Sure. So force majeure, of course, the concept we all remember from law school is if a party is unable due to unable to perform due to an act of God or similar unforeseen circumstances, that they can kind of weasel out of their obligations under the contract. This came up quite a bit in the world of COVID. I had more than a few clients call me up and say, "Hey, I've got a lease. I can't. The government say I can't even go open my doors, but do I still have to pay for my lease?" And so, the first thing you're going to do is look at the force majeure provision in the lease, and what does it say about that? And more often than not, leases drafted before 2019 didn't say much about pandemics, but these days we're seeing virtually every contract is going to mention pandemics as one of the force majeure things to consider, just because it's kind of been raised to our radar screen now. But it's certainly not just limited to pandemics. You can have government shutdowns or supply chain distributions or strikes or war. But the key is, as with any contract provision, you just want to be as clear as possible as what is or is not a force majeure event, so that there will be less disputes on the back end with the parties claiming that there's been a force majeure event and the other party saying no, there hasn't.
Yeah, so in line with that, just making sure that you list those events in almost everyone I see now, to Doug's point, like there's a epidemic, pandemic, carve out for force majeure, but if it's not really a risk for them, like they might not need it. So you just have to make sure it's warranted for the nature of the agreement too. Make sure that there's some notice requirements for that, and that if it's triggered, there's some opportunity for mitigation to be an obligation of the person that's exercising the force majeure clause. So did they make reasonable efforts to still perform even in the event of this, act of God? So the different industries might require different scopes. I mentioned the manufacturing one. That was a huge one during COVID. Things were taking a ridiculously long time to come. On the import side, lumber was non-existent. Like there were all these trickle-down effects of the shutdown that people didn't really think about before. So talking that through with your client and identifying what the real risk would be can help you kind of craft an appropriate force majeure for, what the real risk of the deal.
I would say another kind of point of emphasis there is which side of the transaction are you on? Because if say you're a service provider, you're much more likely to be the one claiming force majeure is the reason you can't perform. But if all you're doing is paying cash to somebody, then your opportunity to use force majeure as an excuse to get out of your performance is pretty remote. So we talked about poor and good causes, maybe not good, but better causes. Here's an example of a poor cause on the left-hand side of the screen. Neither party shall be liable for delays caused by circumstances beyond their control. What's wrong with it? Well, it's very vague. What is beyond their control? We talk about mitigation. That seems like just kind of a very easy out for somebody to not comply with their obligations under a contract, which is probably not what you want. So a better example would be here on the right-hand side of the screen. Neither party shall be liable for failure to perform due to events beyond reasonable control, including pandemics, government orders, supply chain disruptions, provided the affected party gives written notice within 5 days and uses reasonable efforts to mitigate. And you can see how it defines that more carefully, adds a notice requirement, has a duty to mitigate. It's still pretty broad in that it still says events beyond your control, but at least it limits it to reasonable control. So you got a little bit more of a fence around it.
Awesome. So we do have a question pertaining to this force majeure. So I've had the act of God language flagged and removed by partners before. Can either of you explain why to use or not use that language?
I don't have a real good answer there, other than maybe it's a somewhat vague what is the act of God is. So if you could be more specific and say weather conditions or if there's an earthquake or something, that way you're not kind of getting into is somebody's heart being changed an act of God. I often see act of God, so it doesn't on its face bother me, but I could see where being more specific would be better.
Yeah, that's a great answer. Next, we have choice of law and forum. Melissa?
Yeah, this is one where you can actually have a lot of back and forth with people, surprisingly. And I understand why the longer I've been practicing, right? But there's a difference between the choice of law and the forum. So just to reiterate what that is, you can choose which law governs and then where your dispute is held, and they don't have to be the same. So you could have Texas law govern, but agree that your dispute is going to be held in whatever, North Dakota, right? So you can make them the same or different. Oftentimes they're aligned, and a lot of times in my practice, because I'm working with smaller clients, they're both in the same state, but they are sometimes contentious because it can be really impractical for somebody to have to go to a forum that's all the way on the other side of the country in order to enforce their contract. So that cost and the outcome of just having that one state changed can be actually very significant. And also, I don't want California law governing my Texas contract, right? We have different things going on in our judicial system. So you just want to make sure that it's in line with what is practical for the client, and make it as least disruptive as possible in the event you actually have to enforce the agreement.
Yeah, I would agree with that. The choice of law I think is important, but I feel like the forum in a lot of cases can be even more important because that's when you get into just the the travel costs of litigating in some other forum can just be very put your side at a very disadvantage if you're having to fly all the way to South Dakota to defend yourself.
And we have some drafting tips for you, Doug.
So, tip number one is align with business location and operational convenience. That's kind of what I was just talking about. That if the business is here, if the parties are here, then certainly it's you have a great case to make that the forum for litigating any dispute should also be in Dallas County, let's say. Consider enforceability of forum selection clauses. If you pick a forum that neither party has a relationship to, you might find that the forum selection clause is invalid. So generally, you want to pick a forum where the one party or the other is located, and generally speaking, those are going to be enforced if you pick a forum where either one side or the other is actually located. But in any case, you want to be specific. You don't just say courts of X, but talk about state or county courts of X. And as you guys probably know, there's the Texas Business Court has recently been adopted, and so to the extent you have business disputes, that's an outstanding forum to settle disputes. Beginning last year.
Melissa?
So the poor version of that is this agreement shall be governed by applicable law. Obviously, right? It's better if you say the state that they're going to be resolved in the forum and be specific. Honestly, I would almost, if I saw the poor clause drafted, I'd rather have nothing in the agreement. I'd rather just be silent. So,
Well, we had a lot of fun coming up with these poor clause examples.
yeah. But and to Doug's point, if you can't agree, you can leave it out and then, you can fight about it later. So it's not something that you have to necessarily concede on a certain jurisdiction. You can just agree not to agree and remove it. So I have had that happen before. So.
Great. And Melissa, do you find that parties give enough thought to forum selection and governing clauses? And are there any traps that we should look out for?
I don't think they really look at them at all. I think Doug knows how to it's like, but that's way towards the bottom of the agreement. Their eyes have glazed over by then. But I think where we can step in and educate them on why it's important. They only have to be burned once in order for them to pay attention to that clause every single time. Because if you are forced to defend a lawsuit in New York, for example, and you're a Texas company, like that's going to be a significant burden for you. So I would say if you are reviewing an agreement on behalf of a client, just make sure that they're aware of what that is and the consequence of if a lawsuit is filed so that they understand the risk behind it from a monetary standpoint.
Awesome. That's a great answer. Next, we have the parole evidence issues, the entire agreement clause. This is for you, Doug.
Okay, well, this, as you guys well remember from law school, the entire agreement clause is something that states that the contract is the complete agreement of the parties, that there's no, it's kind of hand in hand with the parole evidence concept of, you sign a contract and somebody tries to claim that, oh, we have this oral side deal that's not in the agreement. So by including the entire agreement clause, that it makes it harder for somebody to claim that there's another agreement that's not part of the written agreement. And it says it's critical to avoid disputes over side promises. I think that's well said.
Yeah, so just this comes up a ton, especially with less sophisticated business owners, right? Or close deals among friends. Like, oh well, we said in an email, we just changed that part. it's fine. But if it's not in the four corners, then it's a dangerous proposition to allow, an agreement of any kind to not make it into the final agreement. So make sure you capture them all. Avoid the integration clause, right? It's like everything that we ever talked about is in this one. But if you have a master agreement and then statements of work or other side agreements that are referenced, like make sure that those all align with respect to what's in that agreement itself. So if there's a amendment that's required, that it typically says any amendments have to be signed by both parties in writing. So even if you amend something via email, that's not signed by both parties in writing. So follow whatever the contract says in terms of making changes in order to protect your client.
This is one where I like to specifically ask the client, well, it says here that it's an entire, this is the entire agreement. Is it? Do you have any side deals that you hadn't told me about or that I should know about? Because it's, not uncommon for a client to have some side deal that they just didn't mention to you, didn't think it was important. So it doesn't hurt to actually ask that question.
Yeah.
So, but in terms of the specific drafting here on the next slide, we have an example of a poor entire agreement clause. This contract is the entire agreement. Well, what's wrong with that? Well, it's obviously very simplistic, but it's the entire agreement regarding what is really I think the key. And so a better clause would be on the right-hand side. This agreement constitutes the entire agreement between the parties, supersedes all prior discussions, understandings, or agreements, and no amendment shall be effective unless in writing and signed by both parties. And so you can see there where it's much more robust. You're not just saying that this is the entire agreement, but you're specifically carving out oral and prior and contemporaneous discussions, and providing that the procedure for amending the agreement.
Yeah, that supersession language is key there.
Now we have some arbitration clauses, some enforceability matters for you, Melissa.
Yep. So arbitration is one that comes up a lot in terms of whether you are, open to that. I feel like there's some industries where it's more appropriate and seen more, but this is requiring the parties to resolve their dispute through a specific mechanism. So if you're gonna eliminate somebody's opportunity to enforce their agreement in our traditional system, right? You've got to make sure that you are very clear on the agreement between the parties and that provision is enforceable. So some of those advantages to doing that, especially in a business context, is it can be faster, not always. It's private, so that outcome doesn't necessarily turn into an opinion that's blasted for everybody to read, and then it can be less costly. I've not. I'll let Doug expand on that too, but the key is for them to be clear and a mutual agreement between the parties.
Yeah, and one thing that the arbitration can besides the fact that it's less costly, one thing to keep in mind with arbitration is, are you going to be a kind of a repeat player before the arbitrator? Because if you're say a securities practitioner, and you have all arbitration provision in your agreement, and you're arguing before the same arbitration panel all the time, that's often viewed as an advantage to somebody that's kind of a one-time player before the arbitrator. So I would say that if your client is a one-time player, often being in front of a court rather than arbitrator can be an advantage.
That's a great tip. Thanks, Doug. Doug, do you want to take on some drafting tips?
Yep. So so just saying arbitration isn't good enough. We want to be specific about what what sort of arbitration, what are the rules that are going to govern arbitration? Is it going to be the American Arbitration Association or JAMS? And then which rules? I think there's several different, and the AAA has several different types of rules. Most often see like the commercial rules of arbitration selected, but you want to make sure you select the specifically which rules and what's covered. Are there only certain provisions of the agreement that are going to be covered, or the entire agreement, the entire relationship? Defining the scope of arbitration, and how are you going to select the arbitrators and the venue and the governing law? Probably the governing law is elsewhere in the agreement, but the arbitration section often includes, are we going to arbitrate in Dallas or somewhere else? And is it going to be a panel of arbitrators, and who's going to pick them? And all that should be part of a well-drafted arbitration provision.
Awesome. And Doug, I was drafting some NVCA docs the other day, and I had to choose between AAA and JAMS. If the client doesn't have a preference, is there a default, or do you see them pretty equally used?
So I tend to see the AAA more often than JAMS, but typically when I see that, I call one of my litigation partners and ask them which they prefer, because I've never arbitrated in front of either of those panels. I don't know, Melissa, do you have a preference?
I do not. And really, I think we were joking. It comes down to maybe if you've had a bad experience in one, you'll go and gravitate towards the other. So I've had attorneys that are like, I'm never doing that again, and then they only do one or the other now. So, but that's excellent advice. Just get feedback of your colleagues, and it might make a difference too in terms of the location of the arbitration, and then like the industry too. So get feedback from your peers if you really don't know, to maybe get the best advice. But theoretically speaking, they both arbitrate disputes. So making sure that you specify is the most important thing.
Melissa?
Into good versus bad here. Any dispute shall be arbitrated. Okay, well, no specificity on the rules, where, when. So the best practice here is to make it more specific. An example on the right: any dispute arising out of or relating to this agreement shall be resolved by binding arbitration under the commercial arbitration rules of the AAA before a single arbitrator in Dallas, Texas, and governed by Texas law. So I think we can all agree more specific.
Great. We've got some practical tips and takeaways. Doug, you want to start us off?
Okay, so when we talk about drafting and risk management, the draft for the court interpretation, I think this is probably applies to any contract you draft. Ultimately, it's kind of it's meaningless unless you can convince a judge or a jury that your interpretation works. So think about a judge or a jury reading your contract and trying to decide what it means as you're drafting it. You want to understand the client's risk profile. It could be that the client is, it could be that the business, sometimes the business risks kind of trump the contractual risk, and so maybe a client might agree to a provision that's less favorable to them in the contract because they understand that there's business risks that are much more important to this particular matter. Update your templates regularly. This is obviously important as laws change, and they do change. Then don't just grab an old agreement off the shelf. Let's make sure it's up to date. Use red lines to educate clients. I think anytime you can. I get where I just can't even look at a document that hasn't been redlined anymore. It's so much more convenient to see, okay, this specific change that we want to make, rather than trying to guess what changes were made. And a couple of great sources so I guess a lot of times in negotiations, you'll have the other side say, well, I don't think that's market, usually when they don't have a good reason for whatever position they're taking. So one good source to say, well, is it really market? The ABA's business law section puts out a deal point study where they look at thousands of deals and what sort of provisions often get adopted by the actual parties in real life. and then SRS Acquium has something called a market standard database, which is kind of the same thing, only it's you can use it. It's kind of what's I'm drawing a blank on the term, but you can basically put different parameters into it. So say, I want to see only small deals, or I want to see only energy deals, or I want to see only deals where one party is 10 times bigger than the other party. And kind of this dynamic database is really helpful sometimes, depending on the deal. So those are two great resources you can point to say your side is market when the other side's claiming that it's not.
Awesome. So now we have some Q&A. I'm going to start us off with a few questions, and then we can open it up to the floor. So if you have any questions, go ahead and use the Q&A function in Zoom, and we'll be monitoring them. So first, for you, Doug, how do you explain the risk of these clauses to clients who are focused only on price or deliverables?
Well, I think it's important to just kind of slow down and say, okay, you agree to the price, but well, let's talk about some hypothetical things that might happen. And would you be okay with it says here that you're going to indemnify the other side for their own negligence. So even if they burn down your whole building negligently, you're going to still be responsible for it. So to the extent that you can put real world examples in front of them and see the risks they're taking, I think they're going to appreciate spending a little more time getting these smaller provisions or seemingly smaller provisions right rather than glossing over them.
That's great advice. I think we're all writing that down right now. Okay, next one is for you, Melissa. Do you have any tips for junior attorneys to become more confident in redlining these types of provisions?
Do it more confident you become. I think for me, it helped to explain why I'm change so that you can understand the basis for it. Always get to know your client as well as you can. That helps a lot. If you're a young associate and you just get handed something and you have no background, that's really hard to understand what you should be redlining, right? But there's key provisions that you'll see over and over, especially in these boilerplate provisions where, making sure scope and are clear. So materiality, reasonableness, like when somebody is supposed to do something, is there a specific time frame? Is there triggers for mitigation? So just thinking about the real world scenario as you draft, and then being able to articulate why you made a change, I think can go a long way as you sort of get the reps in for drafting these agreements as a young attorney. So
great. And now
along those same lines, I would say don't be afraid to just ask why. If the other side wants to make a change and you don't understand it, hey, explain this to me. There's kind of no shame in that. And there's so many times that I'll think I'll know why they wanted to make a change, but when they explain it to me, then it's maybe something totally different than what I had in mind. So just keeping that dialogue open is helpful.
Yeah, that's great. Doug, when you're given a contract that was prepared by someone else, what steps do you take to review it and identify issues or changes?
Well, so one thing I always try to do before I start looking at an agreement that's coming in from the other side is to come up with a checklist in my own mind, or sometimes even write it down of provisions that I expect to see, because often once you start reading the other side, you kind of fall into their kind of way of thinking about the world, and maybe you forget provisions that you'd want to see. So to the extent you can kind of on a clean slate come up with a list of provisions that you want to see, I think that can be helpful to digesting the incoming provisions.
Awesome. So if anyone has a question, this is a great time to put it in the Q&A function in Zoom. But for my last question that I have for you guys, in your practice, what's the most surprising way a boilerplate clause affected a dispute or transaction?
I like to use the example of the forum clause. I had a client who moved across the country and she didn't update her agreement. She said disputes would be held in Washington state with Washington law. And when she hired me, she had moved to Texas. And it's like, well, you're going all the way to Washington. Is it really worth it for this, $30,000 or whatever it is by the time you retain your counsel and you're traveling up there and doing all the things and ultimately, she's dropped it. And that happens a lot, but it doesn't have to happen. Like make sure that even just practically you can be where you want to be when you enforce the contract that it's under. I'm sure Doug has some doozies though.
Well, yeah, definitely the a forum selection provision that makes you scratch your head is definitely something that's not uncommon to see. Just because it's so easy. You can have a county listed deep in the middle of a governing law section, and so you end up in a county or state that you weren't expecting to be litigating in. So that definitely comes up more often than not. But I would say the one area that doesn't get a lot of attention that I think should get more attention is the notice provision section. So you've got um, usually the notice provision section will say, how can you get notice? Can you do it by email? Can you do it by FedEx or hand delivery? And how many days after you drop it in the mail is it considered delivered? And I really try to avoid having any sort of uh, kind of old-fashioned provisions in there. Sometimes you see like you can do notice by fax or telex, and it's like who even uses fax machines anymore? So really kind of think through: is this actually a way of using carrier pigeons? How are you getting these notices out the door? So making sure that however they do it, and is your client, maybe if you have an older client, maybe they don't not on email that much, and so maybe you shouldn't permit email as a way of giving notice. And other clients are really tech savvy and they prefer that to on dead paper.
That's a great point, Doug. I've actually seen a lot of the fax language being redlined out these days because people don't really fax anymore. So that's an interesting point. We have a question for someone who may be a litigator and drafting a contract for the first time. What is the biggest thing you'd advise them to pay attention to while drafting?
Well, one thing that kind of drives me crazy about a poorly drafted agreement is if the defined terms aren't consistent. So, maybe you call some party the buyer here, and then we call them the purchaser somewhere else, and then we call them by their company name in a third place, or you give more than one defined term to mean the same thing, or define the same thing two different ways. Just kind of create a lot of confusion. So I would say focus on making sure that every defined term has exactly one definition associated with it and use it consistently throughout the agreement.
Yeah, that's huge. And really where it creates so much confusion and ambiguity if, the defined term is used it differently in multiple places. So that would be a really good one. And also don't be afraid to use if this is your first time, go grab some templates. Look at what has been accepted in the past. Go to those resources, and none of this is reinventing the wheel. None of it. So as much as it's intimidating to sort of do something from scratch, especially if you're more on the litigation side and you're gravitating towards transactional now. Go and use the resources that you got. Practical Law and Westlaw, they have some really good forms. They also have like Q&As for you to discuss with your client as you're drafting those forms. So there are a lot of tools. Like this is not something that's beyond anybody that went to law school and passed the bar exam. Like just use the resources at your disposal. Make it easier on yourself.
Especially if you're dealing with a publicly traded client, you can look at the Edgar database as such a valuable resource that they're required to keep all their material agreements online. So I had a matter one time where the other side was I'd asked for a change to be made, and they said, "Well, we never agreed to that." And so I Googled the last three deals they did, and they'd agreed to it the last three times. So it's very hard for them to say, "Well, that's no, no, we can't give you that provision that we gave for the last three times we did the deal." So that public information is out there, so access it.
Those are some great tips. And also the NBCA forms for any companies just starting out. Those are also really great along with those resources. Okay, we've got one question. Can you go into depth into super caps for limitation of liabilities and which provisions would be appropriate for super caps, such as confidentiality that is carved out of indirect damages, indemnifications, data breaches, etc.?
Yeah, yeah. I guess I'm not sure. I'm not sure I'm familiar with the term super caps, but I guess in context, I guess it means some sort of cap that's over and above other caps that you've negotiated.
Uh, yeah, like a general cap would be 100% of contract value for all claims, but a super cap would be like 3x the contract value for confidentiality breaches or like something specific.
Yeah, I just think that's going to be so facts and circumstances based. I think it's a little bit hard to answer it in the general like this. Um, but yeah, I would think for sure you kind of think about the different types of claims that might arise and whether or not the base cap is appropriate for that. And if and like I would say for confidentiality and IP would be two areas that you could really be harmed by somebody that you might want to subject those to a higher cap than maybe run of the mill damages.
Yeah, I would agree. Confidential data, security breaches, like intellectual property, and maybe like willful misconduct, gross negligence in certain instances, but really damaging. But so can an uncapped, so can a super cap. So the weighing those two, but those are the most common where I've seen them. It's like an increased cap, if you want. I'm with you, Doug. I haven't heard super cap, but we're too old.
Speak for yourself.
Oh, yeah, we could have a whole session on baskets, caps, tipping baskets, all those. There's so much to go into there. Well, we're at 1 minute left and we've answered all the questions, which is great. So thank you all for coming today. Especially thank you to our panelists for educating us and taking your time and effort to be here with us. I know we all learned a lot. We really appreciate your time. I hope this session gave everyone a fresh perspective on boilerplate provisions and that they actually really do matter. So you don't want to skim right through those. They can make or break a deal. A reminder, the CLE course number is in the chat, so please take that number and self-report to the State Bar of Texas. And we love to see everyone at our next CLE or DAYL social event. I hope everyone has a great rest of their afternoon. Thank you so much. Thanks so much, Doug and Melissa.
Thank you.
Thanks, guys.